Carrie Johnson. I'm originally from Putnam County, from Columbus Grove. I graduated high school there a long time ago. I went to Miami University for my undergraduate, and then I did go to UT Law for law school. After UT Law, I moved to Atlanta and worked for a big firm that has hundreds of attorneys all over the world. And they had a very big practice of attorneys that do primarily nothing but trademark and copyright and franchise work. Also had patent attorneys. To be a patent attorney that handles inventions on or applications to register patents on inventions, you need to have a technical background so that you're prepared to handle mechanical engineering, electrical engineering. So to be clear, I don't draft patent applications. I have colleagues at work that do. I have done patent infringement litigation, but in terms of inventions, that's another area of intellectual property that's available. I know some of you are very familiar with that. I've been talking to some engineers in the room. We're going to talk today about some of the other areas of practice, including trademarks and copyrights. So I chair Eastman's intellectual property group, and trademark and copyright is a huge thing of what we handle, but we also handle domain name disputes, data breaches, data management. I think I mentioned franchise, which is ancillary to trademarks because you have to have a federally registered brand to have a franchise. So we kind of run the whole gamut. What you can expect today is we're going to talk about trademarks. What are they? How do I federally register? Why should I federally register? And then towards the end, I wanted to reserve time to talk about copyright. We'll get into a little bit about what is copyright, just so that you have an idea of the subject matter. But the main thing I wanted to talk about is the increase I have seen in, some people call it troll litigation. I might also be one of the people who call it troll litigation, but the people getting in trouble because of posting on social media. We all have the ability to control our marketing so much more effectively and easily, but we also then inadvertently post things that could get us into trouble. And I have seen a rise in those types of issues in the last 4 or 5 years. And so I want to save time at the end to talk about those things, like what actually happens when these things occur, and the practical things we can do to hopefully avoid being the recipient of one of those types of demand letters. So we'll go ahead and dig in. Make sure it's advancing. Yes. So what is a trademark? I hope you leave here today and you actually know this, because you see movies and TV and they'll say, I didn't copyright the name. That is not the correct term. It's trademark. Trademark is, what do we call this thing? So trademark is, again, what do we call this thing? I think you said this little speaker is called the owl. So you would know if you've ever bought an owl that it should look like this. Maybe it has certain things that work really well because you know the certain characteristics that are attributed with that particular brand. So this is why we call trademarks source identifiers. If you go to a McDonald's, you know roughly what kind of burger you're going to get. It's not going to be flame broiled. You know kind of what to expect because you're familiar with the brand. Trademarks can actually be any number of things, which you can see on the screen. Words, symbols, symbols combined with words, stylized lettering. There's also a big category of trademarks that is a little bit too deep in the weeds for us to get into today, called non-traditional trademarks. I'm the chair of a global committee of 150 plus attorneys that are, as I said, globally, that are dedicated to protecting and enforcement of non-traditional marks, which includes things like color marks. Scents, the scent of Play-Doh is a registered trademark, if you can believe it. Sounds, holograms. These trademarks are becoming more important because of the way marketing is so sort of ambushing you, especially with, I think, younger people that are online all the time. And we've moved away from traditional marketing, making things like color more important. So you see T-Mobile has bright pink, and it's because attention spans are shorter, and non-traditional marks can be a little bolder way to catch people's attention. Pretty complex to register them and protect them though. So you'll see the examples I put up here of the types of trademarks we were just talking about. The first three are word marks. Word marks are the broadest form of protection in terms of registration. And then you get into additional ways to register and protect your trademark, which is logos. The color pink is registered by Owens Corning on insulation. They were the first party in the United States to register the color pink in 1985 and to persuade the trademark office that pink is added to insulation. It doesn't naturally occur that way. There's no functionality to having it be pink other than for you to know it's Owens Corning brand and whatever values you attribute to Owens Corning. It's a predictable brand, been on the market for a long time, so you know if it's pink. And they actually have a number of building products registered under the color pink in the United States. So that is their source identifier. The great thing about trademarks is, unlike other types of intellectual property, there's no limitation on the duration which one party can own a trademark. Use it or lose it. If you are the first comer to the market, you stake your claim, you're using that trademark, you keep using it, it lasts forever. When I first started at my big firm in Atlanta, Disney was scrambling, because remember, a million years ago, early 2000s, Disney's copyrights were expiring. So they started exploring registering some of their characters as trademarks, because they realized this is an unlimited right that you're acquiring so long as you protect it the right way and use it. Here is a question I get all the time. Oh, I'm not sure, does that go away? Well, anyway, it says registration of a business name in the Secretary of State's office does not equate to acquiring trademark rights. So I'm sure that many of you have set up an LLC or a nonprofit or something. The first step is you talk to your attorney and they tell you whether the name is available. And then you get a yes. You may think that means this is your trademark brand, it is yours, you should never get a demand letter. That is not the case. Partly you need to consider that I've had clients with an LLC name that's something like, ABC Inc., but they're doing business as, Bob's Mom and Pop Shop. You don't actually have to use the LLC name as your storefront name. So the Ohio Secretary of State is not giving you a guarantee that the name is actually available as a trademark. They are just saying they will reject a business name if it is not distinguishable upon the records from other previously registered names. Part of that is I need to be able to search the Secretary of State's office if I need to serve a complaint on someone. So you have to be able to search and find the LLC name, because registered agents for LLCs are in the Ohio Secretary of State. But from a trademark perspective, these are from the Ohio Secretary of State's rules. These are examples of names that are different enough that they would allow it to be registered. So let's look at Sam's Cleaners and Sam's Cleaning. If I'm Sam's Cleaners and 3 blocks down the road, Sam's Cleaning opens, and they are ruining people's clothes because they're not good at what they are supposed to be doing, dry cleaning, I'm going to be very upset when people are asking me if I'm affiliated with them. Or maybe they're not ruining clothes. See, people are still asking me, and I'm worried, what if they do start ruining clothes? You have a right as a trademark owner to protect the goodwill of your brand. And that's part of what we're here to talk about. But what should happen when you're setting up an LLC is the business attorney should recommend that you do online searching, or that you connect with a trademark attorney to be sure that we're good on 2 fronts. Because this trigger point of the Secretary of State clearing it disappoints people when they later get a demand letter because they didn't realize that. So it's something we've been, I talk about this every year at Eastman's business seminar in the spring. I just think it's a really important thing for everyone to know. So we talked about trademark rights are based upon use in the United States. The first thing, 2 things you want to think about when you're picking a brand, either your company name that you're going to use on everything, or just particular, items that you're branding or particular services. One we need to worry about is anyone else using it that's going to object to what we're doing. And 2, we want to choose a strong mark. We'll talk about how to choose a strong mark on another slide. But to decide if a trademark is available, You can search on the US Patent and Trademark Office website. The internet address is up there. I think they have made it more difficult to search because they did update their, it's called TESS, TESS database. I thought it used to be really user-friendly, and I think it's not as user-friendly now. So that's unfortunate. But you want to search the internet, but of course, internet searches are limited geographically. You would get different results in a search than someone in California would get. So there are some limitations. The sort of gold standard is to hire a trademark attorney to conduct a trademark clearance search. We have databases that are more sensitive to picking up phonetic equivalents, vowel substitutions. I mean, all of the, we also can limit to certain fields of goods and services because your rights extend to the goods for which you're using the trademark or services. You don't get rights to everything unless you are famous. Like Tiffany's, you know, Tiffany's for jewelry, Rolex. I can't have a Rolex men's sportswear line because it's just when brands are iconic and famous, they can cross product lines. But generally speaking, when I'm talking about protecting a trademark, it means your business, your goods, your services, and anything logically related where the public might think you would expand into, you know, these other related goods. So again, trademark clearance search is not required by law, but it is a very smart first step. It also helps us me as your trademark attorney, to know the landscape of trademarks in the US Patent and Trademark Office so that I can tailor your goods and services to make my negotiations with the trademark office more successful than if I was sort of flying blind without that search. Of course, I have the infamous McDowell's. If you've seen Coming to America, the guy opens up a burger joint called McDowell's. He's got the Big Mick, not the Big Mac. Everything is trademark infringement in that with McDowell's, and it's just funny because then the McDonald's people are chasing him the whole time. So I talked about picking a strong mark. By this, I mean legally strong. Courts examine this factor. If your mark is strong, you have a greater ability to stop people from encroaching upon your brand and what you're doing. This shows the range. If we start at the bottom, you get no protection for generic terms. People need to be able to use generic terms. No one should be allowed to have proprietary rights and cause other people not to use them. Descriptive terms like cold and creamy is my brand of ice cream. Ice cream is cold. It is generally creamy. In the United States, you can acquire rights to descriptive trademarks, but you have to use them for at least 5 years, significant promotion. Other countries do not allow registration of descriptive terms. So it's definitely, you know, you're not going to have a very wide breadth of protection if cold and creamy is your trademark. Suggestive terms is where I see most people falling. The example here is copper tone for sun tanning preparations, just because copper tone tends to have some things where they want people to get tan, you know, oils and things. So it suggests that you're a tan. Arbitrary is where people use existing terms but apply them in an arbitrary manner to a product that has nothing to do with the term, such as Apple for iPhones. And then the strongest is coin terms like Starbucks. Starbucks has a very impressive record of enforcement, and part of that is anybody that uses star in connection with something else on coffee, if they try to register it, they're going to get a nasty gram from Starbucks because there's almost no logical relationship between, you know, star and coffee. I mean, maybe someone could get away with something like, you know, Stacy's Stargazer's coffee, like something really unique. But if it's star plus another term that's short, I think you're probably going to end up battling Starbucks because they actually watch all the trademarks that are filed and get alerts. So it's ideal if you can go fanciful or arbitrary or suggestive at minimum. Descriptive is so tempting because I know you want to tell everybody all about your product, but you're better off in the long term if you don't have a descriptive mark because you're going to spend more money to defend it, to keep people away from it. It's better to spend that money branding and to promote your suggestive, arbitrary, or fanciful brand and get people to know, you know, connect it with your product. So I said that trademarks were based upon use, right? So why do we bother federally registering? if rights are based upon use. One, you only get to use that wonderful R in a circle symbol if you have a federal registration. If you have a state registration, you still technically have a common law trademark. It is not a federal registration. You get legal presumptions in court that help to make your attorney's job easier. If you have an infringement issue, you have a presumption of ownership and exclusive rights to use the mark nationwide in connection with the goods and services and the registration. Then I mentioned that state registrations are considered common law. Common law and state, what that gives you, if you're not registered, you only get, if you're registered in the state, you are presumed to have rights within that state. If you are not registered anywhere, you only have rights where you can prove your mark has achieved market penetration. I've sold goods here. That changes over time. So that's really complicated. I handled one federal lawsuit involving two parties, my client and the other party, both had pending applications in federal, the US Patent and Trademark Office. So neither party was registered. The judge could not keep it straight. The judge kind of, I thought, discounted our clients' positions because they weren't registered. And then we had the battle of who came first, where, and when, because the other party was just a little bit of a distance away, but everybody was selling, across state lines. And it cost a lot more money to have to figure out those rights, because that's a lot of depositions to prove who was where and when, because you could have a situation where you're carving up the country and sort of splitting the rights, which we don't want. Amazon brand registry requires that you have a pending federal registration application or a registration if you want to be on Amazon. And then you also need a registration to complain to Amazon that people are infringing on Amazon. You can record your trademark with customs. I have just a small handful of bigger clients that do that. That helps to prevent the importation of infringing goods and even deals with some gray market goods. And again, I mentioned federal registrations last forever, so long as you continue to maintain the registrations by the required deadlines. And we can talk a little bit about that in the coming slides. So how do you register? You say, I'm interested in doing this. Let's do it. The nuts and bolts that you need, aside from the whole, let's clear this and make sure we're not wasting money. Because if you attempt to register and you fail, then you've just lost the money, right? And the failure could be because there's a prior application or registration for the same mark or something similar that then is a block. But the standard filing fee is $350, could be as low as $250. There's a lot of bells and whistles that you have to, things you have to meet to get that $250, but it's definitely possible. Plus the attorney's fees. You have to have a sworn statement verifying it's used in commerce, and that means more than just the state of Ohio. We're talking, and that's pretty easy to do in Toledo. Even with just a service-oriented business, we have Michigan customers here. The only people that I say decidedly cannot and should not register in federal is cannabis companies, because it's not federally legal. They can still have a path to registration, but they can't register on goods that are not considered to be legal at the federal level. You have to describe your goods and services in the application. There are 40-something classes that the US Patent and Trademark Office uses to characterize goods. For example, clothing is in class 25. The classes don't mean anything to you. They're just used internationally. The Canadian system uses the same class system. So internationally, most of us follow this classification system, and it's used for filing fees. So if you load up your application with a whole bunch of different goods and services, which you really do not need to do in most cases, it's going to cost you more because it's going to be $350 per class. You will need to know the date of first use for each class. Month and year is sufficient, and a specimen of use, meaning an example. So if I stick with my clothing example, we need to see a hang tag or a website with an add to cart. But your attorney can help guide you. The specimen of use is the typical stumbling block for someone who's not represented by counsel, because the trademark office is very picky about what they will and will not consider to be an acceptable specimen. There's one exception to the use requirement that I mentioned. You can file based upon intent to use. This is very helpful. So you can seek registration of a trademark if you've not started using it yet. Your rights will date back to the date you filed, assuming you perfect that registration process and you register. This is very helpful for companies in the drug industry, for example, or any other highly regulated industry that need, where people have a lot of formalities. It's also just helpful for people who want to go out and market and feel protected that their trademark application is pending, because even though you may be using the mark first, maybe you aren't meeting the legal use requirements from the legal trademark perspective, but also if somebody else does slip in there and file and then you have to get them out of the way, that's costly and inconvenient. So intent to use, it's the same filing process, except you don't have to give a date of first use and you don't have to give a specimen of use. There are some increased costs down the road because you do have to prove as a condition of registration. If you file intent to use, eventually you have to prove you're using it. So the trademark office reviews your application, they decide everything's in order, they issue something called a notice of allowance. You then get 6 months to file a statement of use or to file a 6-month extension of time. You can get up to 5 extensions. So you can keep an intent to use application pending for about 3 years easily. You just have to keep paying the fee every 6 months for the extension. This stuff I know is pretty dense, so hang with me. So how long does it take to register? This is a big question that I get a lot. Until COVID, it took about 4 months for them to pick up the application. After COVID, they now take 9 months is my standard answer. The website yesterday said 8.2 months for the examining attorney at the US Patent and Trademark Office to pick up your application. The good news about that, though, is you spread out your costs, right? You pay your filing fee, you get 8 months to recover from that before the next potential cost comes in. It's about a year and a half until you get a registration certificate. It can take longer because you file, an examining attorney reviews your application. They will issue an office action almost every single time. Office action is just an email that they send your attorney saying minor things like you need to revise the goods and services statement. It's non-standard, or there's a prior application for a mark that appears to be an obstacle to your registration because you're likely to cause confusion. Something more substantive like that is going to take a little bit more for you to get over, but you get 3 months that's extendable by another 3 months, so 6 months to respond to the office action. So you can really stretch out the process if there's a reason to do that. And sometimes strategically, maybe you filed intent to use and you're nowhere near being ready to use it. That's a free extension as opposed to, well, the first 3 months is free, as opposed to rushing through and getting to the allowance point. But the point being, count on it being about a year and a half minimum until you get that federal registration certificate. Most of it just waiting time. So I'll mention this too. It's also possible to register a trademark in the United States based upon, for example, a Canadian application or Canadian registration, and then you would not have to prove use. So there are some complexities due to our international treaties. You also could file for protection for your trademark in other countries. You can file directly in the individual offices. There are also a number of sort of group registration strategies. One is to file through the EU. You can get all the member countries that are in the EU by filing in the EU IP office. There's also the Madrid Protocol. Anybody who's familiar with the PCT International Patent Application process, this is comparable to that. For Madrid Protocol, you get a registration in the US and use that as the basis for an international registration. And then you can check a bunch of boxes for like, here are all the countries that I want that application to be filtered out into the national offices. So it's a streamlined way of applying for registration in other countries. But I will warn you that the Madrid Protocol can be very thorny. Canada only recently joined, and as a condition of joining, they said, WIPO, the organization that administers these, will not send rejections from the Canadian Trademark Office to a US attorney. We will only send it to the company. That is a way of forcing you to get Canadian counsel because they're being protective of keeping Canadians working. But part of the point of Madrid is that you're filing it all through me. And we don't have to get attorneys in every country unless we need to. There are some built-in landmines that are very well concealed about Madrid, which is why I loved it 20 years ago. I don't love it as much anymore, namely because of that thing in Canada is a great example of the pitfalls of not knowing what you don't know with respect to the Madrid Protocol. There's a time and a place for using it, though. I mean, I certainly would do it. It just depends on the countries that are involved. So we'll just sum up the trademark best practices and then give you all some time for questions about trademarks. Two things I always think about from a trademark perspective. Is it clear for use and is it clear for federal registration? Because there's two different things. You know, one, make sure it's clear for use via the trademark clearance surge, which can also help develop strategy to optimize your odds of success of registering. You should definitely talk strategy with your trademark attorney, let them see your website, let them see marketing materials to identify your brands, identify if perhaps you might be using brands incorrectly. You can lose trademarks if they become generic. Aspirin used to be a trademark, for example. These things tend to happen when with very unique scientific goods in particular. This is our battery is running low. So the point is develop a game plan with your attorney for registration of important brands. You do not have to register for every single thing you offer because that can get expensive. Try to be practical, register for the most important things. If you're manufacturing in other countries, consider registration there. China is its own unique and very thorny beast. Deal with someone who is very experienced with China matters. And you know, US attorneys like me have networks of attorneys all over the world. And so that's how we manage, like I do global portfolio management for a couple of Fortune 500s where we take a global picture of disputes. If I pick a fight in Canada and the US, am I going to have a problem in Europe? You know, so if you are in the international realm, you want someone who is familiar with issues impacting the international community and that has a good network of trusted attorneys in other countries to help streamline your efforts to protect and enforce your brand. Before we move on to copyright and social media, which I think will be a little bit more lively than some of the nuts and bolts, do you have any questions about trademark protection enforcement?
Don't you see, like you use that circle with the R, isn't there one, a circle with TM on it?
There's a TM, or sometimes you see SM.
Okay.
TM means trademark. SM means service mark. Excuse me, which is the same thing. Some people like to say service mark if they're in a service industry as opposed to offering goods. But generally speaking, I would say use the TM if it is not federally registered. So if it's your trademark that you claim, and maybe you even have a pending federal registration application, but you don't have the certificate yet, you use the TM. When you move to registered status, you can put the R in a circle.
You mentioned use it or lose it.
Mm-hmm.
What is the criteria for using it? How often does it have to appear?
I will tell you the legal standard for abandonment, which can help guide you, because you actually do have a lot of leeway for cessation of use, particularly if the company is undergoing a sale, for example. There's a presumption of abandonment if you have not used the mark for 3 years and you have a demonstrated position of no intention to resume use. So 3 years of non-use is sort of the low-hanging fruit as a trademark attorney when we're saying, did they abandon it? First, we look for the 3 years. And then I say, what's going on behind the scenes that we don't know about. Because if they have an intention to resume use, if they are peddling that division of the company to sell it, that is considered use. It's sort of an excusable non-use in the marketplace, but a court, I have seen courts find like even 8 years of not using it in the way that we would all think is use. Well, it still is your brand, you're still leveraging it, you're still trying to determine a fate for this brand. So it's not legally abandoned. So you want to be really careful about assuming something is abandoned. Legal use of a trademark in a valid way. This is such a tough thing, and it's not my client's favorite thing, but you never want to use your trademark as a noun. It should always be an adjective followed by some sort of generic wording. Let's talk about Jello brand gelatin. Because Jello was on the verge of becoming generic because everyone refers to the gelatin dessert as Jello. Band-Aid brand adhesive bandages. These are clunky marketing campaigns. Nobody loves the way it sounds. The marketing groups hate it. The trademark attorneys are like, well done, because you're saving your brand from becoming generic. Kleenex, you might notice, now makes paper towels. And that's their effort, I think, to make people think of it as a brand and not just as the thing. Give me a Kleenex. Like, well, did you want a paper towel or a facial tissue? You know, no one talks that way, but trademark attorneys. But if you have a brand that is in danger of sort of being bastardized that way and used as a noun, then you want to talk to your trademark attorney, let them review your website. I mean, I'll just do it the really easy old-fashioned way, print it and mark it up with a red pen and say, have your people make these changes. We need a couple of blatantly good uses of the trademark so that we can demonstrate legally sufficient use, but also so that we have good specimens of use that the trademark office will accept. If anyone's in the clothing industry in particular, that's a tough one. They're very hard on that, as saying, you know, things that are just splashed across a shirt. They say, well, that's not trademark use. That's just ornamental. But there are ways to get around that in terms of easy ways to use the trademark effectively, as long as you have the advice of people who are used to navigating the trademark office. Does that answer your question? Yep. Okay. And then go ahead.
How do you refer to a competitor that, let's say, has search engine optimization keyed in on a phrase that's a trademark, and it has really high domain authority, and you want to be able to get part of access to that search, but it's not your word?
So trademarks can be used in keywords. There was a big debate about that a long time ago. They can be used in keywords. You cannot have a trademark appear in a sponsored listing if you click the link and then it goes to a page that does not actually sell those goods. So if you know what I mean, when you do a Google search or something, Google is a trademark that I just bastardized.
I can't place an ad with the competitor's trademark name in the ad copy or in the, is that what you're saying?
It can't, the trademark cannot come up in the sponsored listing that results unless you are a true reseller of those goods. You can purchase keywords, you know, the behind the scenes keywords. It used to be meta tags was the thing that drove traffic on the internet. Now it's keywords, and who knows what it'll be.
That's all pay per click. I'm thinking about like organic traffic, if there's anywhere I can use that so that I have actual search engine optimization, as opposed to like a search engine marketing. I want organic traffic.
Honestly, I'm not sure, because you're getting into some technical things about driving web traffic that are beyond my expertise.
Can I use their phrase in copy, I guess?
You mean in your own marketing?
Yeah.
You can use a competitor's trademark so long as you are using it in comparative advertising.
Okay.
And what you do there is don't use the logo, don't use it in a big splashy way. For it to be fair use, it needs to be used nominatively, which means you're not using it in an attention grabbing way. It truly is just, I'm comparing brand A with brand B. So that is allowed. With that said, if you have a contentious history with a particular party, I would be very careful about that, because whether it's legally correct versus whether it will trigger a dispute that you then have to pay to deal with are sort of two separate matters.
I have a question. Since you brought up Google, isn't Google is almost a verb now? So does
They're on the
that-
verge of becoming generic,
Yeah.
although they have, I think they have a lot of brand recognition, but they are, I'm sure, in a full-time campaign, sending letters to tell people, we appreciate how much you admire the brand. However, please recognize it is a brand. Please use it
Mhm.
correctly. If you can demonstrate to a court that you have that kind of track record of enforcement, I mean, you know, the really big monster brands like Google are probably going to survive a challenge
Mhm.
because they have good attorneys who know how to navigate the system to avoid becoming generic.
How often do you need to have the registration on your ad copy and that sort of thing? Like, for example, like with my shirt here, if you look very closely, you can see the R's there. Does that need to be there, or?
So no, the R in a circle use, you should use because it can help you to get damages in court. You can say, the defendant knew because look, I used the R in a circle, they were aware. It's not as critical as you might
Okay.
think. I mean, I typically do tell people on your landing page on your website, give me one big splashy A+ use of the trademark. If you have an article, if you have headers, maybe in the first big header, use it, but I do understand throughout text, it can get a little
Yeah,
clunky to be using the R in a circle and everything. So, you know, it's something you definitely could send to your trademark attorney and say, just wanted to run this past you. This is what we're doing. I mean, they could take 15 minutes to skim over it. And as long as you're not using it as a noun, because I do find that a lot in articles, that trademarks become these particularly scientific technical apparatuses and things. People then, everybody in the industry then starts calling this new scientific apparatus by your trademark, and that's a problem.
yeah, because when we were doing our redo our website, each page would say like E3 meeting, and it was like circle R, all the way through. And it just kind of settled on, let's get it in the beginning, and then it's kind of implied throughout the rest.
That's what I usually
Yeah.
suggest as well.
Cool.
You said you need to have the trademark pending before you can sell something on Amazon trademark.
You need to have a pending federal registration application number to give them.
Okay.
Unless that's changed in the last 2-3 months. I doubt it. That's Amazon brand registry. It's an easy way for them to streamline their enforcement, is to say, you've got a pending application. I can see that you, Carrie Johnson, are the correspondent of record. That way I can communicate with them. So it just checks a lot of boxes for Amazon.
And that happens when you submit, it's not at that 9-month point when they send back.
You could file an application, you get your serial number today, and you could go to Amazon brand registry within, I'd give it 3 or 4 days, because you want the stuff to populate in the US Patent and Trademark Office's database. Your trademark examining attorney is then gonna, or your trademark attorney, whoever filed it for you, or you if you filed it yourself, Amazon sends a note to the correspondent of record for the trademark and says, hey, someone's trying to register this on Amazon brand registry. Here's the code if that's okay with you. And so then we routinely send those to our clients. And then the client just gets it and can then continue with the process for Amazon. Mhm. And if you can get things taken off of Amazon if you've got a registration, much easier too. Well, let's move forward because I've talked too much. So I can make this quick because I think the examples are going to be the more important thing. Biggest things for you to take away. Copyright. Remember I said earlier, trademark is, what do you call this thing? Copyright is meant to protect the creator of works, things that are creative, songs, music, text, can even be educational text. If I created it, I own it. I own the copyright. It's meant to protect the little guy, the person who made it. So you as companies need to remember that when you are hiring people. Copyright ownership means I have the right to copy it, reproduce it, perform it, display it, distribute it, make derivative works based upon it. You can register copyright in the US Copyright Office if you have any manuals or things that your work that you create and put a lot of time into, those can be registered. Like I had a company that does pharmaceutical education for pharmacists, and they have a lot of materials that they've registered. This is a very important thing I want everyone to remember. You don't actually have to have US, the C in a circle, the copyright notice on it. So people see things on the internet and they go, it does not have a copyright notice. I can use this however I want. I will go forth and use it. That is a problem because uses today are so visible that you can get in trouble. If somebody claims copyright in the thing that you saw online that you wanted to use, I think that these cases, which happily had we had an explosion of these types of cases when the internet came out because people were visible in marketing. And then they kind of went down a little bit and now they're back. And I mean, they never fully went away, but I think they are back because of bots. Bots are searching the internet for words, for song titles, for characters, trademarked things. So it's a lot easier for people to make an industry out of litigating over what we might think are small infractions. But if they're getting $1,000 a pop with each time they send a demand letter, then it makes it worth their while to enforce. So real quick though, examples of things that could be copyrighted: photos, artwork, music, computer software code. If you develop software and you want to protect it, you can protect it by patent, which is expensive and time consuming, but it is possible. Or you could actually register the copyright code. Architectural drawings, of course, I think most people are pretty aware of. This I'm gonna move really quickly past because we don't have that much time, but if you hire someone to create a website, if you hire someone to create a logo, you as the company will only own it if there's an agreement that states that the independent contractor is creating works made for hire for your company, and they also simultaneously assign all rights to you. If it is an independent contractor, not a W-4 employee, they own it when they made it. Doesn't matter if you paid for it, doesn't matter if you have an agreement whereby they say, I'm making this and I'll have the deliverables by these times. A lot of people don't know this, but it is so. I have had this argument on almost 2-3 times a year. So again, if it's a W-4 employee of yours, you do not need to have an agreement in place. Copyright automatically arises in the employer. You might want to consider having that language in your employment agreements anyway, particularly with respect to patents, because you do need your employees to assign the rights to patentable inventions to you. But in the world of copyright, we need to make sure our independent contractors have signed an agreement that says these things. So there's a separate slide dedicated to the independent contractor wording. If you have forgotten to get it in writing and the work has already started while you are working with the contractor and everything's going wonderfully and they like you and you like them, say, hey, contractor, would you mind signing this assignment for the 4 months of coding you've already done for me or for the web development you've already done? But moving forward, my attorney has required that we sign agreements, and then put an agreement in front of them too. The assignments are very short. You can go as simple as possible. I mean, literally like a half page. I find that most people are very open to signing it. If they refuse, you could negotiate a license, like a irrevocable license to use it in the manner that you were planning to use it. But getting the writing is always the most important thing. So this is the part that I promised we would talk about. Using photos, music, hiring third-party marketing companies in social media, and why these things are such an issue. Partly they're an issue because people are handling their own marketing. It's so easy to handle your own marketing and post things to Instagram, Facebook. So many of these scenarios may or may not be real stories. Identities will be concealed, but I have a lot of information about these types of things. What if you want to do feel-good movies every Friday, showing the people in your restaurant, your store, whatever, your employees dancing, and you put music, and you post these videos every week for 3 years, you will get a nastygram from the many, many music publishers. The longer you leave posts up that have music, the worse it is, because they kind of use a tax schedule for calculating what they should have been paid for an online use of this duration that's commercial in nature. So I recommend that you do not put music in your marketing unless you have obtained a license from BMI, CSAC, ASCAP are the 3 big ones. GMR is a new one. The concerning thing is there are new publishers popping up every day, so it's harder to get your arms around who they all are. But BMI and CSAC are the 2 to start with. If you have a store and you want to play music, if you want to play music on hold on your phones, there's all kinds of packages you can negotiate. And then you can always go to that music catalog to say, we're doing marketing, let's pick a song from the catalog that we have licensed.
What would they charge you, like, if they came back and you had that music?
Oh, it could be $15,000, $20,000.
So if you're doing like social media marketing and you're doing like an Instagram reel or a TikTok and there's music, you assume if it's an option to use, then it's been gone through the legal process through Instagram or TikTok?
Yes, because TikTok has, I know specifically had a program where they were clearing certain music that you could use. So yes, if the platform states these things are available to use, you should be safe to use those.
Okay, if you're using it, like add the music there, but if you're doing a video and you have the music in the background, although sometimes I think they flag you and say, we don't think this music is,
What I've seen with
Appropriate.
TikTok too is mostly they just pull it down.
yeah.
The big thing with copyright is enforcement and infringement litigation is expensive. So you always want to think, can I do this? What's the likelihood I'm going to get on the radar if I'm wrong about this? What's the likelihood that this party is going to object and come after me? Unfortunately, this is my slide to address, but isn't it fair use? Because everyone says, isn't it fair use? I'm barely using it, or I just used it for this. It is only fair use if it's non-commercial for the most part. If it's commercial and you've added nothing to it, you've changed nothing. If you've used the whole thing or a significant portion of a song or the whole photograph typically is used, then you have taken away that party's ability to license that work for that purpose. So technically, if it's theirs and they could have licensed it and you're doing it without, then you've just made the case for it's not fair use. And I put that up there because everyone kind of, when we go through these examples, those are the questions that are asked, including this one. There's an inspirational poem and I want to post it. And this is true as a business Facebook. They posted an inspirational poem that had nothing to do with the business. They just thought it was cool in a feel-good moment. This person that owned copyright in the poem is suing people all over the country, including educational institutions, aggressively suing. He's been sanctioned himself a couple of times because of his litigation tactics. But the bottom line is he's sending things out when he sees the poem, and it's copyright infringement, whether you meant to do it or not. There's no bad faith intent required. Again, the notice is not required. So it's out there on the internet and you think, I can just grab this. No one put anything about, there's no watermark or there's no other indicia that I shouldn't be using this. So you want to be very careful, particularly posting to your business, anything, something that you are uncertain of. This is another one, photos. Photos are tricky because you think this is a benign, easy thing. I'm going to put a picture of a tree on my website's homepage, or I'm going to post a picture of a school bus on my business Facebook account to say it's back to school time, just for whatever reason. Both true stories, both resulting in needing to pay a license fee. In a situation like this where you post a picture, the photographer is going to say, I normally would have licensed this for an online use for a duration of 6 months for $700, but because you have done it without permission and I'm now giving you a retroactive license to settle it, I'll take $2,000. So what I typically do if I have a client raise these issues is I say, let's talk as quickly as possible so that you're barely paying me. And then you go try to get the fee reduced, because it doesn't make a lot of sense to hire me to negotiate down from $2,000. But if the rate is higher, then I certainly will get involved, because just having an attorney involved can help get the other side to negotiate more
Would
quickly.
you normally get a cease and desist first?
Yes, these things normally come in with a demand letter. Many times people ignore it. They're like, I got this letter, this can't possibly be legit. It's over this or that, or the common reaction is, I took the photo down, this is gonna go away. Doesn't go away. If they've sent the letter, even if it's on sometimes the photographer sends it, or photographers tend to be the ones I get most of the time, but sometimes it comes from an attorney. Some of these attorneys are in a volume business, and it's kind of mind-blowing to talk to them for how these types of cases are handled. It's like a claims processing, they're just churning and burning. And my mantra as an attorney is, the fastest we can settle this for you makes the most sense, because you're going to pay something. So there's typically no way, unless the amount in controversy is like $20,000, $15,000, it doesn't make sense for us to like over lawyer this. Let's try to get it down to the most reasonable possible amount, with you paying as little as possible on attorney's fees, and then move on in your life. Celebrity pictures. Let's go with this one instead. Same vein. Can I use an ad campaign? A professional marketing company created this for me, and it has the likeness of Elvis. What do you think about that one? This is fraught with issues. This is a no. Right of publicity is something that famous people have. It's basically their trademark rights in the value of their persona, their name, their likeness, their voice. Now, Tennessee has recognized because of Elvis, Tennessee has a lot of right of publicity laws, but with AI generating voices, they've now said that distinctive voices are also entitled to protection. So there's a post-mortem right to control celebrity likenesses. And of course, while they're alive, it's their right of publicity and also trademark rights. The fact that it is a campaign created by a marketing agency hired for you doesn't necessarily mean that everyone involved realized that this is a no-no. So, this does not happen much, because ad companies are typically pretty good about these things, but I have had occasion where this comes through, and it's just a tough situation all around, because a lot of money goes into having a third party create a marketing campaign for you. And then you end up, if you have an infringement situation, it's difficult. I think this is my last one. And then, yes. Oh, places you can, just to point out, you can get stock photos. Like I mentioned earlier, you can get not stock, but songs. These are some websites where you could pay a modest subscription fee and then have as many different photos that your marketing person might want to pull from, so that you feel safe in having some generic pictures. If I had more time, I was going to put a bunch of pictures in my slides of like my kids and things. These are all clear. I took them myself. I own the copyright, but I did not have enough time. What's your question?
So with that, you hired a company to do the work. Earlier, you talked about like if you hired a company and you didn't have the W-4, there was different levels of protection.
Yes.
If you hire an ad agency to do something and they do something that is not supposed to be done, do you take on the responsibility for that, or can some of that be pushed to them?
Typically, there would be a provision in your contract where they indemnify you against infringement of any third party rights. But copyright infringement is, unfortunately, that is your company's liability for using it. Possibly the ad agency could be contributorily held liable by the copyright holder, but it's not limited to just like one person in the chain of infringement when it comes to copyright. It's it's same thing with trademarks. You know, even if you buy and then resell goods in your store and you think they're genuine, if they're not, you could be held, liable for trademark infringement, which happens, unfortunately. It does go to your willfulness, and there are enhanced damages for willful infringement of trademark or copyright. So if you've got a marketing campaign that was created for you by a third party, it certainly says, well, I didn't know, I thought because I hired them that they were running things, they're not running things through an attorney. Imagine what your bills would be. They should, and I have had some marketing companies like sort of keep me on retainer so that we can help them clear these things before they're proposed to clients. Any other questions about social media or copyright? I apologize for going quickly. I wanted to get to the end here. I've actually had people get up and like run from the table to go take something off of their website, like while I was talking. So I'm not suggesting any of you has any issues, but I know that it's very easy to inadvertently have one of these problems come up.
How about content that you originated that's, we're a construction company, so we're at someone else's facility taking a picture of work that we were contracted to do. Our photographer goes out, but we don't own the facility or their logos, things like that, that may end up in pictures.
I think the only thing potentially objectionable there is if they didn't want you to include the logos, it's not going to be a demand letter or trademark infringement. You don't want to get sideways with a party that you were doing business with.
Sure.
But it is a fair use. You're saying, unless there's something proprietary in the picture, it's, you took the pictures, it is a fair representation of this is our client's work, our client's site, we did the work. We always ask permission before we post things about clients on our website, just because it's kind of safer.
We do too. I mean, we have a procedure for that.
But there's no right to that kind of background. I once received a demand letter on behalf of a shed. Someone took a picture of a shed. I'm like, you let them onto the property, you let them take the picture. There's no right of publicity in a shed. There's no Cleveland Hall of Fame copyright, amazing structural integrity here with respect to the design of the shed. Turns out the guy just wanted his limo ride he was promised and a case of moonshine because it was on the label of moonshine. You never know. Creative settlements can happen all the time. Anybody have any other questions?
I have a very specific question that I've had a difficult time getting an answer to. I'm from Walt Churchill's Market, grocery store. People come in all the time with pictures that they want put on a cake. And we don't have the ability to license. There are some things we do have access to, but people will get very angry if we say we can't really do that. A good example would be Ohio State or Michigan. Somebody, they want to have this put on a cake. But if we hand draw that block O, we're potentially in some trouble, yes?
Yes. Potentially, yes.
So
I do see this happen all the time. I think we all see those types of cakes. This is a situation where you say, one, are you taking pictures of these cakes and putting them on Walt Churchill's website?
it's when a customer will come in.
No,
and say,
you are not, of course. So the exposure there would be if the client takes a picture and says, Walt Churchill's did a fantastic cake on this amazing Ohio State themed cake, and then they post it. I think the worst that you would get is probably a letter from them saying stop. Ohio State's very aggressive about their trademarks. The Ohio State University is very aggressive about its trademarks.
But it comes up with, many other.
Well, I know that
things
if
as
you
well.
go someplace back in the old days when we'd go to Kinko's and make a copy, and they'd say, I can't copy that. If it's like a book or something that you wanted to copy, because of technically it's infringement. Because remember, copyright protects the bundle of rights, including the right to copy and distribute. The Copyright Office won't even make specimens of use available. You have to physically go there and look if you want to see something because you have to deposit materials for like a sample when you register copyright. And unlike the Trademark Office, where you can go through all their records and see specimens of use, see like the example of the trademark in use, you can't do that for copyright because technically that's copyright infringement.
Okay, thank you.
Yeah, well, go ahead.
Going back to trademarks, would you recommend that every business get a trademark for their company name, or is it?
I think it's worth exploring. I think it's, I mean, if it's a coffee shop in the middle of Iowa and they don't do any business outside of the state of Iowa, because it's a big state and they're in the middle, and they really don't have a lot of interstate commerce, you know, and they don't want to franchise, then, you know, maybe don't register that one.
If you're gonna sell nationwide, then
Yes.
it's a really
Yeah.
good idea to do that.
Nationwide sales, and people are manufacturing outside of the US these days. There's a lot of Brazil, China, Mexico production. Those are smart places to consider registering because of infringement.
Not just manufacturing, services too.
Yeah, oh yeah, I mean, certainly if you're offering goods and services too, but sometimes in outside of the US, people forget about the manufacturing facilities too being important. Well, why don't we wrap it up since we have lunch, and then anyone can find me with further questions, but I appreciate you all listening. I know it's a bit of a dense topic.
Just a quick, what would be the total cost of getting a trademark? Like including attorney fees and
Yeah.
all of it?
So people charge differently. I have seen some attorneys that say 1,500, all inclusive of the prosecution all the way through to the registration. I've also seen a lot of people say $1,000, that includes the filing fee. You will notice online services that charge 1,500, 1,700, and they put it out there like that's a bargain. I don't think that's a bargain. I get a lot of work from those cases, from people just kind of cowboying it through a service, because I don't think they do any clearance from what I've seen. They'll file it, get an objection, and then perhaps suggest that it's possible to overcome the objection, and I'm like, it's not, we're not gonna win this one. We need to go back to the drawing board and refile. So I really do recommend talking to an actual attorney for that process instead of, if you're gonna do an online service, maybe just do it yourself. The trademark office is fairly navigable. I don't know if the process is 100% navigable, but I think that their office online filing is pretty decent.
Okay, well, thank you, Carrie. This was great.